So I'm excited to talk to you today. We haven't talked in probably about a year, and so this will be great. First of all, for the audience who's watching for the first time, can you tell me a little bit about yourself and what you do at Goldwater?
Sure. My name is Chris Thomas. I am the director of legal strategy for education policy at the Goldwater Institute. I've been here at Goldwater for about a year and a half, close to that. My background is that of an education attorney. I started working in education policy back in the 90s and then went to work for the Arizona School Boards Association, first as their lobbyist, and then later as their attorney, which position that I held for 22 years. So, and then after that, I went into private practice, serving school district clients and helping them out with their legal issues. So that's my background, so kind of mixture of public policy and school law and representing school districts.
Do you love what you do?
I do love what I do. It's funny. I'm about to talk to some interns in a couple of weeks, and I was thinking, what do I tell them? And I was, what I would tell them is like, you don't know where you're going to end up. Get yourself as the best education you can, expose yourself to a number of different situations, but know that where you start is not where you're going to end.
That's true. I'm 50. Well, we don't have to say what the number is actually. I'm still trying to find out where I'm going to end up. So.
Yes, we all are. It's the road's not over till it's over, and you never know, and you never know what opportunities will come up. But I love it here at Goldwater.
So let's talk a little bit about this bill that now is a law, HB
Sure.
2514.
Mhm.
How did you get the idea for this? And how did you make the connection with Justin Olson?
Yeah. So, again, with my background with school law, part of what I had to do was write policy, and I was very familiar with the Family Educational Rights and Privacy Act, which is a federal law that protects um, the privacy interest of student information. Basically, any records that are held or maintained by a school district, parents have the rights to see those records. They have a right to correct those records if they're incorrect, and they have a right to keep those records from being released to people who shouldn't be seeing them, including the public. But there's a class of information that is called directory information, which is things generally that don't involve a big privacy interest, at least on the surface. The student's name, what their dates of attendance were, whether or not they participate in any kind of club, uh, those dates of birth, things like that, that are not seen as being so personal to a student's records. They're not their grades. They're not, any kind of disciplinary record or anything like that. Um, that's a separate kind of class of information that says that, this, as long as the school district tells the parents at least once a year, look, this is the type of information that we're classifying as directory information, and unless you object to us releasing it, we're allowed to release it. It's not a violation of FERPA if we release this information. And that's what the law was. I wrote policy to that law. What had always sort of bothered me was that, especially in the computer age, the internet age, some of this information does have a personal nature. Somebody could troll and find out information about students and then, piece together the data that's publicly available from maybe other sources and violate the privacy rights of both the students and the parents. So I felt like the law on its face didn't go very far enough, and that what the law really required for to make sure that parents' rights were upheld and the students' privacy interests were upheld was to actually require affirmative consent. That the parent would actually have to, in writing, say, "You have my authority. my consent to release this information. And that's what this bill does. It's just very simple, saying that for certain basic information, you have to get affirmative consent. And the reason it's needed is that if you've had kids that have gone through the school system, you know what the beginning of school is like. Maybe that first week or first 2 weeks, your kid comes home with a packet of information.
A ton of it.
Yeah, a ton of it. It's got every, the student rules of conduct, the expectations of all the teachers, what classes they're taking, the whole thing. It's a big packet. And you're expected to read through that packet. And, if you're a good parent, you do read through it. But you're going to get, some of that's going to get lost. And my guess is that the FERPA notice is one of those things. And so you just kind of glance over it and you just assume, well, I this is fine. I mean, I don't mind if my kid's name shows up in a program for the football team. That's fine. But what you don't realize is that unless you object, then the school district can release that information to anyone, and that could be third parties, for instance, like people who are marketing yearbook pictures, or people that are marketing class rings, or some other sort of tutoring programs, or other clubs. Now, some of that might be something that you would want to get information about, but some of it you might not want to. And once the school district releases that information to these individuals, then it's just out there, and they don't have control over it. So I think that parents ought to go in with their eyes open and say, here, either we consent to this release of this information or we don't.
I remember when my daughter was in public education here in Arizona, and we would get these letters in the mail saying, "Oh, we think that you'd be great for a pageant." Every year it was the exact same letter, and I was able to trace it back to the schools had sold the information.
Mm-hmm.
My daughter, when she was little, she's like, "Oh, I could be in a beauty pageant." It's like, this is just one more way for people to try and make money, with this
Right.
information. Um, are there any other states that have a similar law?
There's one other, and that's Virginia, which passed it, I think, in 2019 or so. So when I was researching this issue, I discovered the Virginia law and said, it was kind of one of a kind. I think Governor Youngkin was instrumental in making sure that happened, and because he's been all about parental rights. And we thought this is a good idea. Let's bring this to Arizona and sort of tweak it for Arizona law. But the idea is that, just very, very simply, instead of an opt-out requirement that you have to, take certain steps and be aware of the law and be aware of the policy and opt your kid out of a system that allows for the release of that private information, you instead should opt into that system. Very simply.
You bring up something that's really important, because I have gone back, I have watched the evolution of this from start to finish. And one of the questions that came up, Democrats had a big question about FERPA law and how would state law override FERPA law.
My understanding, which is small, of FERPA laws is that they would allow a school. So what I'm concerned about is if a school did give the information out following FERPA laws, but not following the state law, they would be in violation of the state law, or are they okay because of the federal law?
Yeah, thank you, Mr. Chair Center. So again, the FERPA doesn't require the disclosure of this information. It's essentially just saying...
No, it allows. So it gives them the right to disclose the information, but then the state law says you have to give parents permission first.
Mr. Chair, so yeah, I think we're saying the same thing here, which is FERPA isn't mandating the disclosure of this. It's essentially saying data that's designated as directory information that the school discloses to parents as designated as directory information, they can share in these ways. This simply adds, in alignment with FERPA, an additional safeguard that says we're going to have parents actively opt into it, as opposed to having to fill out a form and say, I want to opt my kids out. So it's not clashing with FERPA. It's just essentially saying we want parents to sort of know that they are affirmatively saying, yes, you can take my child's data and you can share that with additional organizations.
From what I understand, it doesn't really change the information is just the button, right? Are you opting
Right.
in or are you opting out? Can you explain that, please?
Yeah. So and this is one of the comments when the bill got over to the Senate, there were some interesting comments that I wish I could have responded to at the time, because one of the things that was said was that, well, this is the right of schools to release this information. I know people don't like to think of schools having rights, but this is the right of schools to release this information, which my head was spinning, because the school doesn't have a right to release this information. The parents have a right. Um, the feds have just set up a system by which the parents only have to be given an opportunity to opt out. But the right, if there is a right there, it is the privacy interest of the student data, which belongs to the student and it belongs to the parent. It's not a right of school districts to release this information. So I thought that was kind of interesting, because the bill, when it went to the House, through the House, and with Justin Olson's sponsorship and stewardship of it, it had no opposition at all, and then got over to the Senate, where there were some questions being asked, and I thought sort of unfair, and I'm glad, frankly, glad that Governor Hobbs saw that this was pretty common sense, that this is protecting student privacy and giving parents the right to be able to decide for themselves whether or not they want this information out there.
I've been following privacy issues since late 90s. And one of the things that I have found is, it really kind of started out with more of your Democrats or liberals really, on it about privacy. And then you have a situation here where in Arizona, we had our Democrats who were voting against this policy for privacy. What is your experience? I mean, is privacy a right or left issue?
I don't think it normally is, but the dynamics that are going on in the Arizona legislature right now are interesting. Uh, I think sometimes the merits of an issue aren't fully considered, and instead folks just look at who's for it and who's not for it. And if they're if it's a group that they think that they may disagree on other issues with, and therefore some legislation, it doesn't matter whether or not it's a good idea or not. And sometimes that just gets mixed up into the process, and they end up voting no on things that, absent their bias against a particular group that's behind it, they would support.
Okay, so I have a question for you. I am working on an upcoming investigation looking at consent forms in general for school districts. I came across one district that has a consent form for mental health screenings. And it was one of those you have to opt out. So automatically your child will get a mental health screening if you're not paying attention to the forms. What are your thoughts on the mental health screenings?
Well, I generally don't like those kind of laws. I don't think Goldwater would agree. I mean, Goldwater would feel the same way, which is that parents should affirmatively have to consent to those kind of things, to give parents their full rights, because there is a law that's in Arizona that says that no one can usurp the parental rights of raising your child. It's a fundamental right to be able to raise your child, and I think when you're talking about the mental health of your child, that's a paramount public parental right, and that they ought to affirmatively consent to that kind of screening.
What other opt-in or opt-out forms should parents be watching for this year?
Well, so one of the things that also House Bill 2514 accomplished was, under the law, there was school districts were required to create a Parents' Bill of Rights. Basically delineate a policy that delineates all of the rights that parents have with regard to state statute, and reduce that into the form of a policy. The law said that before House Bill 2514, that it allowed the district to distribute that to parents, either in an electronic form or in a paper form. It did not require the district to distribute that to parents. It effectively required parents to go to the district's website, seek out where the district's policies were, find that policy, read that policy in order to get that list of all the things that they have the right to do under the statute, under the Parents' Bill of Rights. Again, we thought that was kind of crazy too. If you're going to have to create this policy and you're going to have to, delineate what rights parents have under the law, the parents ought to get a copy of what that policy is, and they should get that policy on an annual basis. And just like they would the FERPA notice or any, whether the rules of conduct are. So this law changed that as well. So I think didn't get a lot of attention, I think, when the bill was going through the legislature, but it's very common sense and it's a substantive change.
One of the things I noticed in your testimony in the Education Committee, you talked about some of the harms of the sale of directory information, and one of them was stalking.
We think that releasing this personal identifiable information can lead to multiple things that are bad things: exploitation of targeting advertising, harassment, stalking, and other physical safety concerns, and increased risk of identity theft and creation of digital profiles. All those things are things that you might want to assume that risk if you're a parent, but you ought to actively assume that risk as opposed to having a notice and then reading the fine print and knowing that you could object to it if you do it in the right way and in the right time frame.
Mm-hmm. Can you talk a little bit about some of the consequences of this information, a child's information getting out to a third party?
Yeah, I mean, anytime your information is out there, somebody with intent, or maybe somebody who starts with no specific intent, but rather just a general intent to pull together information from public sources, they're able to make connections, and then through website crawling and things like searches, they can piece together other bits of information, and then target a particular individual. Let's say, who knows? I don't like my mind to go there, but let's say that somebody noticed, your child in a public setting and was aware of where they went to high school, and but didn't know their name. And then they did a search and were based on the little bits of information that they had, plus the information that was available that the district has put out, they were able to piece together a little bit more information. And finally, they find out with piecing it all together where they live. And now we have a situation where we clearly could have a stalking situation. So it's just those kinds of things that I think, parents are aware of now. They certainly educate their children about them, but we shouldn't make it easier for these individuals and these predators. And at least parents ought to have their eyes open about what information gets out there.
Okay, so now you bring up the words education. And I recently interviewed Naomi Brockwell. She is a huge privacy expert. She's a producer for John Stossel. And she brought up during our conversation, children's privacy. And I asked her, I said, here in Arizona, we hand these kids a tablet or a computer that they have for 4 or 5 years in school. Are there any privacy concerns with that?
And I do think that parents need to take more responsibility for the choices that they're making for their children and understand the consequences. And I don't blame parents because, again, this world is opaque. They don't probably understand the consequences of their action. So that's why I think that educating people about these consequences is one of the most important things we could do. So parents do understand that their choices matter. They do understand that the platforms they choose matter. They do understand having that camera, forward-facing camera that we've given countless apps, permission to use is being used. tracked, by apps that we're logging into. Microphones are being used to collect data from conversations. They are being used to tag information, sell it to data brokers.
Oh my goodness, that just led to a huge conversation. And when you taught, she had explained that when you have a computer, you have a front-facing camera, and some of these apps are able to do facial recognition and map exactly where these kids had been every single day. What do we do in our schools? I mean, at home, I can have, protections. I can pay attention to what's on my daughter's phone, but what kind of rights do I have as a parent when my kid has this technology in their hands at school?
Well, one thing we should be demanding of our school districts is to make sure that when they enter into these agreements for these kind of services, these learning apps and things like that, that that the privacy interests of students are protected in those agreements. That whoever they're working with on the third party cannot glean the student's information. They can't use the student's information. And most of the time, they're not looking to identify a particular student. What they're trying to do is sort of aggregate data in a very broad sense and be able to sell that data. It's not maybe personally identifiable, but it's sort of in block. Whether you feel that's a good thing or a bad thing, it certainly raises concerns in terms of the execution that it truly is not personally identifiable. But that's one of the things that you would want to protect in those kind of agreements. You'd want to make sure that student data is protected, and that whatever parental rights are associated with that data in terms of the release of that data, that those are protected as well.
So we just have to trust the schools to do the right
Well,
thing?
we have to trust the schools, and school board members that are out there. When that a lot of these agreements come to the school board and they're often put on the consent agenda or whatever, they should be asking those questions as well. Are the appropriate school data safeguards in place when we enter these kind of agreements?
Well, then that brings me back to your bill, because a lot of the people who voted against it are also school board members.
Right, and I mean that gets to my earlier comment about did they oppose it based on the idea, or did they oppose it based on who was supporting it?
What else are you working on? Any other exciting things?
Well, yeah, I mean we're in our policy cycle right now where we're trying to identify different policy initiatives that we will have for this next coming year. And we're a 50-state organization. We look for opportunities in other states to take some of the ideas that maybe were hatched in Arizona. This is one of them that we might be able to work with to implement in other states. And so I support the litigation efforts that are going on here, helping them identify cases and opportunities for us to make sure that individuals can enforce their rights before the government, and to make sure that they're able to live the happiest, freest life that they can.
Have another question for you. So last year, I started looking into some of the teacher discipline cases, through the Arizona State School Board Association. Just the discipline cases.
Right.
And a lot of these cases involve children in texting with their teachers and their coaches.
Right.
So in the state of Oklahoma, they actually created a policy at the state level saying, parents need to be involved in these conversations, no direct communications like that over text between teachers and students.
Right.
In Arizona here, we have a best practices policy, really leaving this up to the schools. What are your thoughts on this? Do we need to have stricter rules here? Do we, again, trust our school boards?
Yeah, and the problem is that so much of that is folded into the certification process. If somebody engages in those kind of boundary infractions, it could be grounds for revocation of the certification. I'm not sure that that's the only way or even the best way to enforce that. There, those best practices, I'm aware of what they are. I think they're good best practices, but they perhaps should have more teeth to them.
So,
Some of them might be embodied in direct state statute, perhaps.
okay. So as we get into the school year, fortunately, my daughter's not in high school anymore. So, but I was one of those, I was a hawk. I watched everything going on. I'm assuming you're probably one of those levels too, of paying attention
Mm-hmm.
to what your kids are doing in schools. What is your best advice for parents heading into the school year when it comes to privacy and safety with technology?
I would just say read the forums, it seems like it's perfunctory, but you should read what is being given out there, and if you object, say you object, and make sure that if you that they're following it. Because the other thing is that with a bill like House Bill 2514, they're going to have to maintain essentially two lists of students. The information that they send out that the parents have not consented to, goes in one category, and then the ones where they have consented in another. And that's a slightly more administrative burden, but not much. But I would make sure that they are complying with that. And again, if your student comes home and says, "Hey, we were on this learning program, and I thought this was kind of weird," take them seriously, and follow up and get some more information.
So assumed consent is not consent.
Right. You could always assert more, your rights that you have under the law. And sometimes it's because of an ignorance that the school district employees aren't aware of the rights that you have and what the law is. And, oftentimes, in my capacity when I was at ASBA, I would get questions from school district employees saying, "Well, what happens if this happens?" And the extent of my legal advice was to pull out their own policy and read it to them because they hadn't read it.
Well, thank you for all you do. I appreciate it. Anything else you can think of that I haven't asked?
No, I think it seems weird to say we're ready for a new school year because it's only July 1st, and we still have some summer left, but it will be here before we know it. My own daughter is starting high school this year, my youngest daughter, and my oldest daughter is in her second year at U of A. So we're definitely in the thick of it as well, so no, it's everybody get those last few weeks of rest and relaxation and be ready to go.
All right. Well, enjoy your
Right.
travels. Have a good time.
Thank you, Jen. I appreciate that.
All right. Thank you so much.
You bet.
All right. Bye-bye.
Bye bye.